Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I'm Thomas Vick, joined by Seth Wilson of Adler Attorneys, and we have a random selection of topics to talk to you about today, topics regarding estate planning and other matters. Seth, how are you today?
Doing great, Thomas. It's always fun to have these kind of collection of questions we've dealt with either in our practice or just things we've run across while drafting a plan, and just things that not everybody has to think through in a normal estate planning scenario.
Yeah, yeah. So, uh, what are some things that we need to know about a living trust? We'll talk about revocable living trust. What are some things that that clients should know when they're doing a revocable living trust?
Well, I think a big part of that is always the funding piece. You always want to make sure that once you've created this living document, that you actually put something inside of it and you're using it for its intended purpose. So that's always kind of the big piece of the puzzle of, look, once we've got this entity itself created, this legal entity, then we want to make sure that the appropriate assets are in that document and governed by the terms of that document the way we want it to be done. And so that's where it gets really interesting, because you have these terms inside of a trust that may be very unique to your situation, that need to be addressed and followed. And if they aren't, there's some downstream considerations to think about. So if the trustee at some point is not doing what it or he or she is supposed to be doing, whether that's an entity or an individual, then there's some rights that the beneficiaries may have under that trust, to enforce those terms, or even seek to change some of those terms to make it more in keeping with what the trust makers or the grantors had in mind.
Yeah, and what you're kind of talking about is who has standing to be able to bring an action against a trustee. And it all sort of depends on whether the trust has been funded. You can't get, if an entity is not a trustee of the trust, and the beneficiaries of the trust can't attack the trustee or try to get the trustee removed or anything like that. And so you and I both spend a lot of time talking to clients about, you've got to make the effort to go to the bank and these other financial institutions and get your assets titled into the name of the trust, according to the specific directions of the attorney that you're working with. So very, very critical. It takes a trip to the bank. Certain attorneys will do deed preparation so that real estate can be placed into the trust for you. And so it just takes some effort, but we've said it before that it's sort of like doing the probate process while you're living, rather than having a loved one do it after you have deceased. And so it takes a burden off of your loved ones, and also it actually gives them some legal standing to be able to make sure that things run the way that it's supposed to.
Yeah. And I think it's interesting too, that the law in Indiana at least continues to develop to recognize these concepts. And we were talking just before we started recording about some changes that are coming to Indiana law in terms of disinheriting someone and being able to give those individuals notice during life, which then gives them a time frame in which to challenge that determination. And what better time to really test what the intent of the estate plan was than when the people who made it are still living. And so
Right.
it's really kind of recognition that this really, a lot of times, these asset transfers are a stair-step process. And one of the other situations we handled this week or recently was a survivorship affidavit for a surviving spouse of a joint tenant scenario on real estate. And the local county offices will want to see an affidavit of death, essentially, that says, okay, I'm now the survivor, and therefore this is titled in my own name, before any other transfer type thing, like a transfer on death deed, would be recorded. And so you got to take step one before you can get to take step two, and so on up toward that transfer. And that's kind of a good way to think about any of these asset transfers into a funding into a trust, or making that transfer is, okay, what's the next step? I physically need to go to the bank. I need to log in to an account and make a beneficiary designation change. I need to call and make sure my life insurance beneficiaries are, and kind of list that out and take those things step by step and make sure that each of those I's are dotted and T's are crossed.
For sure, for sure. One of the things that I think is mentioned in a blog post that went out this week on my website was that there has to be a trust agreement, and in Indiana, the trust agreement has to be written and signed by the grantor, and usually it has to be notarized. At least that's a good practice to have, is to notarize the trust. But occasionally you get these situations where the one creating the trust, the grantor, isn't able to sign. And so there's sometimes this situation where the attorney or somebody else needs to sign on behalf of the individual creating the trust. And there are some specific things that need to be placed into that notary block, the acknowledgement of the notary, that basically says that, so-and-so is signing for the grantor at the grantor's direction and in the grantor's presence. And, there's no coercion or anything like that. It's just that the person is not physically able to sign. And so that sometimes comes up from time to time. And, that's why you want to work with an estate planning attorney that can help you navigate those situations.
Yeah, and it's real practical. Let's say you have a sprained ankle and it's hard for you to get in and out of a vehicle or get up the stairs or ride an elevator or whatever it is to get documents signed. There's often many times where we've met clients in their vehicle and said, or at their home, or whatever needs to be done to make sure that document is properly executed. Because again, using the stair step analogy, you can't skip the steps and then go back and later jump back to step one and kind of correct what you did on step three. It's got to be done, in the right order to ensure that the true intent of that individual is reflected and memorialized appropriately on those documents. And so even things like doing an audio or a video recording of that ceremony, in case anybody would ever question whether mom or dad actually was delegating that signature authority to someone else, can be a very helpful tool to say, no, we did this the right way and at their direction and in their presence, and here's the photographic or video or audio proof of that fact.
Yeah. And another thing that you mentioned about the new change in Indiana law about notifying those that you may be disinheriting, maybe part of that process, or at least part of your own estate plan process, is to decrease conflict in the future. You might have a family meeting where you call your kids together and say, I'm picking the middle child to be the one that's personal representative and trustee, and then you guys are all going to be treated equally, but this is the one that I want to run the show, and give your reasons for why. Or it might be that you have a family meeting and explain, I'm maybe giving the house to this child because this child is helping me out in this way, and I want to kind of pay that child back for that and show my appreciation for how they're helping me, and just give your reason so that the kids understand what the actual intent of the grantor or the client, what that intent is.
Well, it's fascinating because so many of the issues in life that we deal with as attorneys and that we deal with just as people day to day is lack of communication. And oftentimes, if you understand where things are coming from and have information about what that is, that goes a long way to dispelling maybe even preconceived notions or wrong assumptions about what was done and why. And so those meetings can be really helpful to lay out the plan, seek some feedback, get some perspective that maybe we didn't think about. But ultimately, remember that whoever is making the plan, it's their asset and their plan. And so that's the key. And from an attorney's perspective, that's what we're always trying to accomplish, is provide that peace of mind that the plan that you're putting in place is going to get you to the outcome there. And so that may tie in a little bit to the irrevocable nature of trusts, because sometimes you have something in place that you really want to keep in place, and therefore either the trust becomes irrevocable at a certain point, or you make an irrevocable trust that says this is just how it is and this is how it's going to work. But even then, that can come with challenges because we can't foresee the future and situations that may arise down the chain.
Right, right. Well, good stuff. Good stuff. This was sort of a random medley of sorts of topics, but that's good. That's a good thing from time to time. Seth, tell us how people can reach you.
Appreciate that, Thomas. We are located in the heart of Hamilton County, up in Noblesville, Indiana, and our web address is noblesvilleattorney.com. How about you, Thomas?
And I'm Thomas Vick. I'm the attorney at Vick Law PC in Greenwood, Indiana. The best way to get in touch with me is go to vicklaw.org, vicklaw.org. Well, thanks again, Seth. We'll see you next time. Appreciate everyone who tuned in today.
Thanks, Thomas.